Hi, my name is Robert Shelley with Shelley Law, and my law firm assists nurse practitioners with employment contract and independent contractor agreement issues. Today I'm going to talk about what restrictions to watch out for when a nurse practitioner is signing a new contract. And so there are kind of, I guess, two main categories of restrictions in a contract. So basically, if it has some kind of exclusivity clause, meaning you're only able to work for the employer while you are a full-time employee for them, and you couldn't do any kind of side work without approval. That's the first thing. And then the second would be the restrictive covenants, which can include a number of different ones, but the main restrictive covenants that matter to most NPs would be the non-compete and non-solicit. So let's just take the exclusivity portion first, and then we'll get into the restrictive covenants. So when you're signing a contract, and it could be an employment agreement or an independent contractor agreement, there could be language in there that one prohibits, it could be phrased differently, but one, it's most likely called either outside activities. So the contract would prohibit the NP from doing any kind of outside activities, meaning any kind of, they cannot provide professional services for any other employers or organizations as an independent contractor without written approval from the employer. That's pretty standard if you are an employee. If you're a 1099 independent contractor, I would be very weary of signing a contract that has any kind of exclusivity or outside activities prohibition while you're providing independent contractor services to anybody. That's not really the point of an independent contractor agreement. They should not be able to, dictate where and when you're working and for who. And so that's one thing you definitely want to look out for. It is very normal for that to be in an employment contract. If you're an NP working for a hospital network or a hospital, you're almost guaranteed to have some kind of outside activities portion in there. And that's fine. So if you do have a second job that you want to continue, then you need to, I would address that before signing any contract and get the written approval before you sign the contract. There's just not a lot of, reason once you've signed the agreement for the employer to allow you to do that beyond just not trying to tick you off. But you have your highest leverage before you sign the agreement. So you would want to get that handled in advance. So that's the first thing, outside activities or exclusivity. The second thing are restrictive covenants. And so non-compete and non-solicit, and let's just go over both of those, which you need to be careful for when you are signing a contract. And this will go for both an employment agreement or independent contractor agreement. So a non-compete essentially prohibits NP from working as a nurse practitioner, perhaps just in their specialty, for a limited time within a limited geographic area. So just as an example, let's say you're a mental health NP working for, a psychiatrist or something like that. The non-compete would say you can't work in mental health within 10 miles of your primary practice location for 1 year, right? So that's a non-compete. Now, what you absolutely want to do is make sure it's only the specialty that you're doing for that provider. Now, this is if you're not autonomous. So if you're in a state where you can be autonomous and you're working for yourself, then this isn't going to matter at all. But if you are employed, and let's just say you're an FMP, but you're working for, like a gastroenterologist or something like that, you want to make sure that the non-compete only stops you from doing GI activities, not working as an NP completely. You want to have options, right? So, an NP can do, if an FMP can do a ton of different things. They could work in urgent care. They could work in a hospital as a hospitalist, or perhaps an ED, primary care. So you want to make certain that you still have options open. And so it shouldn't just say you can't work as a nurse practitioner for a year within 10 miles. It should be you can't work as a nurse practitioner, doing this specific thing for a year and 10 miles. 1 year to 2 years is normal. And then the geographic restriction really depends upon where you are. If you're in an urban environment versus a rural environment, it just kind of depends. And then there are also a handful of states where non-competes are completely unenforceable. So you would need to check into that as well. And then the last thing would be the non-solicit. So a non-solicitation agreement essentially prohibits the nurse practitioner from attempting to take patients or employees away from the practice. You couldn't, for instance, blast out an email to all your patients saying, hey, I'm leaving or I've left, I have a new practice, please come with me. That's what a non-solicitation agreement would prohibit. And then as far as employees, the same thing would go. You wouldn't be able to take like an MA or a front desk or other nurses with you. If you're going to open up your own practice or just move to a different practice, many non-solicits will say you either can't solicit them or you can't hire them. I mean, the smart ones will say you can't hire them. But that's another thing that you want to watch for. Now, they can't really dictate who someone's healthcare provider is. So if someone reaches out to you and says, hey, I hear that you're leaving, I'd like to come with you, where are you going? I wouldn't consider that solicitation because the patient was initiating the contact, not the provider. But you need to look at the specific language of the non-solicitation clause. So those are 3 things to look out for: outside activities, non-compete, non-solicit. That would be considered restrictions in an NP contract that you need to be careful about before you sign it. So if you have any questions about an employment agreement or independent contractor agreement, feel free to contact my law firm at the contact information listed below in the description, or you can ask any questions. I'm happy to answer them, and I appreciate you watching the video. Thank you.